Salem and Kaiser, and welcome to another show of the Senior Symposium. Today's show is going to be focusing on estate planning, and I urge all of you right now to get out your pencils, pens, legal pad or otherwise, because we have with us the the estate planning attorney, Eden Rose Brown from here in Salem, which is going to give us some very salient suggestions for planning our own wills or modifying them. And a lot of this show will be dealing with misconceptions that we have. Some of it pretty tough stuff that are hard to absorb and memorize. So I'm asking each of you out there, please remember to write down some suggestions and share that with your loved ones, because in the long run, it may help immensely. Okay. Eden Rose, welcome to our show.
Thank you, Lee. Pleasure to be here.
Okay. And our special panelist at large is consumer advocate, civic advocate, activist E.M. Easterly from West Salem. Welcome aboard, E.M.
Thank you, Lee. I do appreciate it. This is kind of an exciting topic.
Okay.
We'll see what happens.
Okay. Now, we don't have any particular script here, so we wing it, as it were, and we're going to just do things serendipity style, which is a kind of fun way to approach it. I myself was a pre-law student, admission, confession, never made it to law school back in my days in New York where they talk funny like that. And so I became a journalist instead for many years, and I still write some material for guest opinions at the Statesman Journal and other places around town. Anyway, we're going to, everybody dies, and it's good to plan for the eventuality and not run away and pretend it'll never be here. And so this is a safety net for each of us in a way. The purpose of today's show is to educate and motivate us and to deal with some of those false impressions out there. What is the main false impression, Eden Rose, that some people have about what a will is all about?
I would say one of the impressions is that they just need a will, that that's all they need. Mm-hmm. When they're just focused on dying, and they're not focused on incapacity as
right.
well as dying. So there's two phases, right, that you mm-hmm. need documents to provide control. One is for disability, mental disability. The other is after you're gone.
Right.
So I would say that's a primary misconception, is that I just mm-hmm. need to check the box and get a will done, mm-hmm. When there's other documents to support that will.
Okay. I'm going to run right into a scenario. Let's say that I suffered a stroke and could not talk. Could I still execute a will?
No.
No.
So once you lose capacity, unless you have an estate plan set up that gives somebody the authority to create an estate plan for you, which we do in our office, you would not have the authority to do that. Your family could go to court and get authority from the judge to do that, mm-hmm. or it could be in, let's say, a living trust or a power of attorney to create an estate plan for you. But mm-hmm. if you don't have any of that, you cannot. Once you lose capacity, you don't have the capacity to create legal documents.
So, but if I still could use the computer or whatever, that wouldn't, I have to be verbally capable of transmitting my thoughts?
Well, the will needs to be witnessed, and it needs to be witnessed by people that declare you to be competent. Uh-huh. And if you're not competent...
But if I cannot talk, but I can do other things, does that put me in a gray area?
Oh, I see what you're saying. If you are mentally competent,
yes.
It doesn't matter if you're physically disabled.
Yeah.
You could actually, you could type.
Right.
You could...
That's a very important thing to know.
Yeah, you could create a document as long as you have mental capacity.
Yeah. Okay. What is the purpose of an executor, and are there some misconceptions about the powers that an executor has in executing the will?
Well, so from the legal standpoint, an executor is the same as a personal representative, mm-hmm. and the personal representative that's actually the current legal term for an executor. The executor is like the quarterback of a will. Yeah. So the quarterback is going to take the will through probate and deal with the judge. Mm-hmm. So I think it's important to get the understanding that the executor or the personal representative only deals with the will itself.
Ian, what would you like to know about will preparation?
I'm queuing in on Eden Rose's comment about more than just the will. One of the questions I would want to ask, when's a good time to do this? I can give personal experience. My wife and I probably never looked at a will until we were in our 50s, and a couple of generations beyond that now. And we went through a process of setting up a will. Then along came my father, and he had a will that needed to be taken care of, and I ended up being the executor on behalf of my father. And he died 8 years ago, and I'm just now finishing up the details of what he asked to be done. So a timing issue is really a question I would have.
So your question is when should you create an estate plan?
Yep.
So let me back up just a minute. There's three ways you can plan your estate.
Right.
The first way is what 70% of Americans do.
Which is?
Nothing.
Oh, boy.
Okay? Nothing. You don't do anything. The second way is to create a will-based estate plan, where the will is the governing document, and that directs how everything will be settled after you're gone. The third way, which I prefer, is I think the preferred way, is a living trust-based estate plan, where the living trust is the governing document. And that's my preference, because a living trust goes into effect the day you sign it.
Let's talk about what is a living trust. And this is also very important for everybody to write down, because it's an important option to consider deeply.
So a living trust is a legal document that goes into effect the day you sign it. And I like to think of it like a dresser. So think of a dresser, a chest of drawers.
Yeah.
And the living trust has different drawers that will open at different times in your life. So the first drawer, as soon as you sign it, is the Alive and Able drawer. And the Alive and Able drawer has all the blueprints and guidelines for you or you and your spouse to manage and control everything about your life. Okay, all your assets,
Wow.
investments, things like that. But let's say, God forbid, you have a stroke or a car accident, or somehow you lose mental capacity. Well, now the Alive and Able drawer shuts and the disabled drawer opens up. And inside that disabled drawer,
New phase.
it's a different phase, different time of life, right?
Yes.
There's a mechanism that's put in place inside that drawer that avoids judges and courts and lawyers and keeps the control of the estate with the family or whomever you choose,
Sure.
right? Right? And it's a nice smooth mechanism, so there's no break in control.
I can't help thinking of the analogy of having a sign in front of the courthouse, "Do not trespass onto my property,"
Yeah.
in a way. Go ahead.
So to me, the number one reason to have a living trust is for control during incapacity. Because statistically, we are 7 times more likely today to become incapacitated before we die than to just die. Well, that's huge. That's a huge statistic. And the fastest growing demographic in our country is people over 100. So we are aging as a culture, right? And because we are aging as a culture, we are experiencing more mental incapacity.
Like a
Right.
Twilight Zone, essentially.
It could be Alzheimer's, it could be Parkinson's, it could be dementia, right? I mean, my own family is dealing with dementia issues.
My mom died of that.
Right. So all of these things, we need to address them as estate planners, and that's why this today is so important, is to get this information out to you, the consumer, right, about the importance of planning for disability and not just focusing on planning for death. Right?
If I could interrupt, I'm an executor for my neighbor. My neighbor she and her husband a half dozen years ago said, would my wife and I be the executors for them, taking care of all the little legal stuff, financial stuff, without ever bothering them in the court is perfectly fine. She's mentally alert.
So are you a trustee?
No,
For them?
I just have the POA.
You have, okay, so there's legal terms, and I want to,
I'll be quiet and
yeah,
let you.
well, no, I mean, that's a great
Power of
comment.
attorney,
Right, so
POA.
there's an agent
Right,
for a power of attorney.
Right.
So you are her agent.
correct.
There is an executor or a personal representative for the will. That's the quarterback of
After
the
the
will.
person is deceased.
Which I am
Af-
also.
right.
Which I am also.
After they're dead.
Right.
And then there's a trustee.
And
That would be over the living trust.
right.
Okay, so those are the three, and then there's one more. The fourth one is a healthcare representative. And that's a critical document.
Advanced directive stuff.
The advance directive.
And
exactly.
that again is, in the case of this individual, I act in that way.
You
So
wear
I
three-
have three
three hats.
Three hats
hats.
for this individual. And one of the most interesting parts of the complication to me is, at this point in life, perfectly rational, but the medical and physical ailments really is restricting the desires of this individual and what they would want to do. And that becomes kind of difficult talking
Crucial.
with family and all those pieces.
Yes.
And so have they put that into their documents as
See-
far as what,
See, that one really is not in a document, and that's what makes it interesting.
right. Right. So when you create these documents, it's important to put in as much information as you can about how you want it to be taken care of if you can't take care of yourself, how you want your funds to be used for your care. That can all be put in the document. That's why these cookie cutter documents tend not to work so well. Right? It's better to have a custom created document that works. But I want to get back to the dressers.
Yes.
Right, the dresser and the different
Three drawers.
So we had the alive and able drawer, we have the disabled drawer, and then there's the death drawer. And each drawer, and then there's drawers underneath for beneficiaries, for charity, for pets, right? How
We'd
we're
like
going
to get into that, right?
yeah, how we're going to take care of everybody. So if you just think of that dresser, the different drawers are going to open up at different times in your life. The biggest thing that's missing from a will is what? Which drawer is missing?
Well, disabled,
There's no disability drawer. And that to me is a critical reason, and to me the number one reason to have a living trust-based plan instead of a will-based plan. Okay? If the living trust is done properly, there should be no guardianships, no conservatorships, and no probate. Okay, and the control stays with the family.
It's a good time to explain to all of us, including our audience out there, what is probate and what are the risks or dangers that the individual takes by making the estate vulnerable to probate.
Well,
It's an outside monitoring sort of.
yeah, if you think about so if you pass away, somehow the assets you own have to be legally transferred. So if I die, how do I get my assets to you? Well, with the living trust, it's easy because the assets are owned by the trust. When I die, the trust says they go to you. But if you don't have a trust, then the judge is the one, the court is the one that's going to make the decision where assets go and how they go. And that they use the will. So the will dictate when I pass away, my assets are going to be transferred to you. But who legally does that? It doesn't just magically happen. Somebody has to have the authority to change titles, to change ownership over to Lee, right? That's what the judge does. So what you're doing is you're transferring control from family into the court system. Okay, so that's one drawback, is the family is going to lose control. A second drawback of probate is it's costly. Right? Generally, 3 to 6% of an estate that goes through probate is going to be lost through fees. Okay? That's fairly substantial. The third problem with probate is the time it takes to conclude the probate process. So anywhere from 10 to 24 months or more. We know of one client whose estate's been in probate almost 7 years. And who controls the assets?
during that time period.
Yeah, well, it's the judge, right? So if you want to sell mom's house, you have to get approval from the judge to sell the house. So again, the control is taken away. It's expensive. It's time consuming.
Yeah. I want to bring an aspect that occurred to me because of a family situation. Safe deposit boxes. Sometimes people put their will in a safe deposit box and think that everything will be, shall I use the term, hunky-dory. And I understand that it's sealed after a person's death and they can't get in so pronto, and so that things are delayed, the court, the beneficiaries and all. Can you explain the drawbacks of having one copy of the will in the safe deposit?
Yeah, that's a good point. It used to be, and so every state has different laws about how safe deposit boxes are accessible. After 9/11, the banking laws, as we know with the Patriot Act and all that, banking laws totally changed and became much more restrictive.
So what's the story now?
Well, the story now is Oregon does not seal boxes anymore. And if you can prove to the bank that you are the personal representative, the executor, they will let you in to get the will. Right? So that shouldn't be an issue. The issue comes with accessing the assets in that box. It's becoming more and more difficult to do that. So generally, what we recommend our clients to do is go to the bank that they have the safe deposit box and do whatever documentation is necessary. Oftentimes, a bank power of attorney that will allow the agent to get into the box if there's a death. You can also, what I've done with my own family is on my parents, we've become signers so that we can actually access the box as signers.
Okay. This brings up another question. In my case, and probably in other people's cases, my executor lives out of town. He actually lives in Florida. Does that complicate the situation greatly?
Well, when you have the executor is going to usually needs to hire an attorney to help with the probate process.
Yeah.
And so that friend from Florida would call us or call a local attorney who would make the process happen.
Okay, good.
So we've got clients all over the the world, really. And as long as we have a representative here in Salem, they can make everything happen.
A question.
Go.
So far, in all the instances I've been involved with, having to go through the court system has not been necessary. I earlier mentioned the fact that it has taken me 8 years to facilitate what was the requirements of my father's will, to close the accounts and all that sort of stuff. Am I breaking the law by not going to the judge?
No, absolutely not. So that he brings
You're
up
off scot-free.
Yeah, the thing is as technology changes, right? And legal technology is just a different type of technology, right? And as things advance, a will, if you go back to the history of the will, it's almost 500 years old, right? It came from the Statute of Wills in England, and
Magna Carta stuff.
well, a little bit after that.
Okay.
But it's the technology of it has not changed in almost 500 years. The only different thing is we don't wear white wigs, right? That's really the only thing.
I could use one.
So as things progress, think about it. All things keep progressing. Technology improves. The living trust is the new technology.
Ah, okay.
Right? So if you think about corporations, it used to be C corporations were the best way to have a corporation. Then technology marched forward and it became the S corporation. Then it moved forward again, it became LLCs, right? So everything moves forward except wills. Wills are stuck in 500 years ago where this new technology has been created. Why wouldn't we want the better technology? Right, of the living trust. It's just a better way to plan. Right?
So you figure the amount that one invests in setting up a living trust with lawyers' fees is more than recouped of what the court would get in a probation setup.
Well, absolutely. It also goes back to providing more control to the family. So, for instance, our average settlement for a living trust is 4 to 6 months, whereas probate will last years. And it's not so much that that probate is evil or anything like that. It's just we have too many people dying for the amount of staff.
Oh, okay.
Right. So because of the economy and so forth, county courthouses have cut staff. It used to be we had 3 probate judges. Now we have 1 probate judge, right? And so the delay is getting higher and higher and higher. And who
Sounds almost like the Veterans Administration. Forgive
Well,
my political analogy.
it's similar, right? And so wouldn't it be better to control that internally with the family and have it settled quickly and at lower cost
Good point.
than to die and have all of this hassle? Plus, you've got the disability issue.
I may get that thing added and all. In what way does the state of Oregon resemble or differ from our 2 neighbors on the West Coast, California and Washington, are we?
That's a great question. The biggest difference we have, I mean, there's many differences in the law, but 2 in particular. One is California and Washington are called community property states.
Which means
that each spouse owns 100% of the assets. So if one spouse passes away, the other spouse owns the assets. There's no probate usually required when the first spouse dies. In Oregon, however, we're not a community property state. We're a separate property state, which means each spouse owns 50% of the assets. So when one spouse passes away, there could be a probate of that spouse's, what they own in their own name, okay, that doesn't go directly to the surviving spouse. So there's, in Washington and California, the cost of probate and the incidence of probate really only affects the survivor. Whereas in Oregon, oftentimes we have 2 probates. One when the first spouse dies, one when the second spouse dies. The second issue is estate taxes. Okay, so for clients that have over $1 million of net worth,
I'll never see that.
no, but many people, you know, if you start adding up, think about it. If you add up your home and your life insurance and your retirement benefits, oftentimes today, families can get over $1 million.
I see what you mean.
So Oregon has an estate tax exemption of $1 million per person. If you die and you have over that, there's going to be
Bye-bye.
an estate tax on the amount over the $1 million. Washington has an estate tax, but it has a $2 million exemption. So a couple can shelter how much?
2 million.
4 million.
4 million.
4 million.
Couple,
Okay.
double
In
that.
Oregon, a couple can shelter 2 million. Right. And there needs to be some estate planning done in order to do that. California is the best. California has no state estate tax.
Really?
Okay.
Wow.
So, you know, some clients like to pick the state where they're going to live, right, based on estate taxes. Okay.
Could be a factor.
It could be a factor, and that's something that we talk about.
Eden Rose, if I may, I asked you a question before, then we sort of got it wrapped
I didn't
around
answer
it.
it, did I?
The
Reprieve,
timing
reprieve.
issue, and I'll use
yes.
and I will use myself as an example. We moved to Oregon 30-some years ago. Really, all we had at that point in time was at best 6 months worth of cash in the pocket, no job, anything, and a retirement that was worth, in retrospect, about $4,000, whatever that meant at that time. We didn't get around to really doing a will until over a decade later. And I'm talking about we arrived with a 10-year-old and a 7-year-old. So
no guardianship provisions.
Absolutely none of that. And we were positive, affirmative people, willing to do things. We even tried to think ahead. And we can talk about that later if it makes sense. But I have to ask the question from somebody who's in the business, what's the right kind of timing when you're thinking about at 40, and that's roughly what we were at the time, what you need to do to plan for tomorrow?
So that's a great question. Let's talk about the myth of estate planning.
Yeah.
Many people that come to my office and that I work with, they feel that they don't need an estate plan until they're old, right? That they focus on age.
I call it mañana-itis.
Mañana-itis, right?
Delay.
When you're young, you don't think about death and dying and incapacity, but you need to, right? All you have to do is read the newspaper and you see younger people having strokes and brain tumors and having a heart attack at Bush Park. I mean, I see it all the time because it's what I do, it's my work. So what I tell people is, as of 18, you should have your estate plan in place. It might be very, very simple.
Wow.
Right? Certainly when you have young children, when you have minor children, you must have something in place for not only permanent guardians, in other words, you and your spouse pass away, but also disability guardians, temporary guardians, because you might get into a car accident and you're not going to die, but somebody needs to take care of those children. So it's critical.
So anybody takes drugs, legal or illegal, should think ahead in these terms as well.
Well, everybody needs an estate plan. It's just, when you're younger, it tends to be more simple.
Agreed.
But the fact of the matter is
property.
we never know when something's going to happen. And if we want to avoid the chaos that comes with leaving a mess, then we need to do what I consider an unselfish act and plan our estate for who we leave behind. And again, it's not just about death, it's about disability as well. So the question is, somebody will come to me and say, I'm too young to have an estate plan. I don't need it yet. I tell them a story of a girlfriend of mine who...
In denial.
Well, yeah, I mean, she had a heart attack when she was 42 years old. You just don't know. So you get it done. I have a slide in my office, and it shows, when should you plan your estate. And the planning opportunity is now. Because as soon, God forbid, you have that stroke or that car accident, we've lost the opportunity. Okay, so you just got to do it.
We're in the age of computers. Is there a website that you could recommend for the average citizen to go look at to get a little bit education about wills and estate planning before they come to a lawyer?
I think the best website is estateplanning.com. I think that's the one. Estateplanning.com. I think that's through the Wealth Council organization of estate planners. If that's not the right one, I will let you know and we'll get it corrected. But I think it's estateplanning.com.
And to find an attorney, one goes to the local bar association or
I would recommend you go to wealthcouncil.com.
wealthcouncil.com.
And look up it through the member directory there,
They will.
where you live and what state you live in.
Yeah.
The reason I like Wealth Council attorneys rather than the bar attorneys is that they're trained in cultural aspects of estate planning.
Let's get into that, because different ethnic groups we have here in Salem, we have the Hispanic, and they're not one monolithic group. You have Mexicans, Guatemalans, Hondurans, El Salvadorians, and so forth. And then you have Russian, Ukrainian, you have the Indian Sikh community, which has, you have Vietnamese, you have some Chinese, Japanese. We had a lot of people turn out for the Tsunami Peace Vigil, which I was part of several years ago, and Tokyo University. And so what are some of the cultural nuances of wills that we should be educated about?
As far as...
Are there different approaches, let's say, that the Russian or Ukrainian community would be taking? Or
Well,
you probably want to translate if they don't speak English, of course. but
well, right. So sometimes we need translators. So
cultural values, are they
cultural values...
radically different?
I'll give you an example. We have one couple that the husband is Korean, and as part of the Korean culture, it's important to take care of the mother right? And it falls to one of the sons
Yes.
to take care of the mother, and that means to support the mother until she passes away. Well, we had to bring that cultural aspect into this couple's plan. We had to actually provide. So if he died early, before his mother, the plan would provide for his mom until she passed away. So every culture has every faith. Right, we have a lot of faith-based clients as well. We bring that faith into the plan if that's important. For instance, kosher foods, or for LDS clients, certain garments they wear. For Catholics, to make sure that they can keep celebrating Mass and rosaries. All of that can come into the plan, right? So it's customized for each culture, each faith, each family, right?
As far as you know, do churches themselves give education on this aspect of death preparation and wills? Or
Some do. I've been asked to speak in several churches, synagogues, a Buddhist temple, in order to help educate about estate planning and primarily faith-based estate planning, right? How you bring your values into planning.
You know, this is a good time to mention, I haven't done this before in a show here, but CCTV, through Kelly at the main desk outside, they produce DVDs of these programs. So any church in town, Salem or Kaiser, for $6 could get a copy of this particular program and play it and have it as a group discussion within your congregation. That might be a cool way to go. You recycle Eden Rose and EM, and then if you want to, I'll slip in as a footnote.
And I'm always happy to go to the church or the place of worship
Or temple.
and temple and do a presentation or hold a discussion. My feeling is the more we can educate, kind of where you were coming from the consumer, the more we can educate the consumer for their choices, then the better choices they'll be able to make. So we can educate to motivate, and then they can make good choices for themselves.
I wonder if in sociology courses, let's say in Chemeketa Community College, whether an aspect of learning sociology, or certainly gerontology, which is my specialty, if that could be integrated into the curriculum. I don't know if it could be.
Yeah, I don't know.
Something for the future there. Chemeketa and Corbin College, University now, and Western Oregon, and of course Willamette. Go for it.
A question for you. Somewhere along the line between telling the personal story of 30-some years ago, there was a decision made in our family to start planning financially for retirement. How does the idea of creating the living trust will package interrelate with that kind of thing? I walked in when Lee first asked me if I'd be a part of this without knowing the full topic. I said, gee, what's the real important thing from my perspective as a consumer? And if I'm talking to someone else, what is it that I really want to say? And the word in my mind is plan.
Right.
Whether it's legal documents for estates or making decisions about fiscal futures in some way.
Precisely.
And I kind of need help in understanding how those two fit together, that financial side along with the estate planning side.
Right, that's huge. And estate planning attorneys, they're not financial advisors, right? But that said, it is such a critical part of the planning process. It has to be integrated.
That was my feeling.
Right, and one of the things we're seeing, and again, because of shifting cultures, we're living longer. For the first time, we are starting to see people outliving their retirement. Right?
Yes.
They have not planned enough. They are living way beyond what they originally expected to live, and they lose their sense of support, their ability to support themselves. So starting now, actually, so I would say starting in your 30s and 40s, to start planning for retirement, putting more away, planning smartly is huge. There's plenty of information online. There are wonderful, wonderful financial advisors in the area that can help you through this journey, this process. But if you get to be 70 or 80 years old and you haven't planned ahead, there could be some problems.
Right, I'm early 70s.
And I'll be honest with you, I do have some clients whose children now are supporting them because they've run out of their retirement. So that's a hugely important question. Yeah.
Lee forced me to think. And I said, okay, what is it that made the difference? Why did we end up as reasonably retired? We spent the first dozen years working and doing things, trying to keep ahead of the world. We didn't own a home until we were into our mid-40s. Just life had taken us down some different paths. And we had to have our two daughters get through school. But the minute that was over with, every dime that we could put away into some sort of a form of retirement package. And so in that last 20 years, we ended up being in pretty good shape. And I said, why? It was because we thought ahead and we planned ahead, and it took two of us. I mean, my wife started putting money into a deferred revenue account where she was employed, and then all the bits and pieces. But it's that the notion of we were fortunate we would think ahead and started planning. And we knocked on doors, not on your door, but we knocked on planners' doors and legal advice doors. And so that was really the message that I wanted to bring. Now, I know I'm just the consumer, but I'm trying to give a consumer's point of view.
Very
if
valid.
you're thinking about it, think today.
Do it.
Yes.
Right. Just do it. Right.
Eden Rose, hopefully this won't be too intrusive. You mentioned about being a single mother, and I'm wondering whether single mothers or fathers have to approach it with a different mindset and a different set of expectations and planning their own wills.
It's definitely different. There's blended families, which are some of the most complex. Right. You got his children, her children.
Yeah.
That's complex. On the other side, you have a single parent who they might be the only parent.
True.
So it's even sometimes more critical to get a plan in place and get the guardianship panel put in place for incapacity and for death.
Exactly.
And so as soon as my daughter was born, I did that. And my daughter just turned 18, and we are working on her estate plan right now. Right?
Well, Mama says we do it.
So she will have, you got to walk the talk, right? So she will have a plan.
Desirable, yeah.
One thing, and I don't know if you want to talk about it now or later,
Yes.
but in addition to wills and trusts, there are two other important documents that we should talk about at some point.
Which are?
One is the power of attorney, and the other is the health care directive, the advance
we can do that.
directive.
I'm going to devote another show to that. So,
Oh, okay, sorry.
Which is on the whole area of disability and disability services. But if you want to briefly mention, then we could allow it, of course.
Okay, well, the important thing, if you have a will, then you must rely on the power of attorney for somebody to manage your financial affairs if you become disabled, right? So that's a critical, with a trust, it's not so important because the trustee has the authority to manage everything, right? But to me, if you don't even get any estate planning done, which wouldn't be it would be a bad idea. But let's say you don't do anything, you should at least have an advance directive. That's a document that names somebody to direct your health care if you're incapacitated.
Okay,
Who
yeah.
deals with the hospitals? Who deals with the doctors?
Let me bring up something that is an idealistic notion of mine, but I discuss it with the executive of the local Red Cross, and she thought it also might pan out. Car accidents. When you have a car, you're in danger of being disabled or sometimes killed. I suggested that it be tested out pilot project style sometime in the future. Listen to this, those of you who are legislators or friendly with legislators, and see if the possibility can come into reality that DMVs, the Department of Motor Vehicles, would make available as part of their little packet of forms an advance directive, and eventually encourage, and maybe insurance companies could give a reduced rate to those who have, well, not necessarily the advanced thing, because each time you are driving, you are in danger of endangering yourself or others. And so to have that advance directive, if you do become disabled, is really very important.
Yeah. Again, for me, disability planning is just as, if not more important than death planning. Right. So it's kind of a living plan versus just a death plan. Right. So the advance directive would be part of that.
How does one go about choosing objectively which friend or relative gets the advance directive? Some might be more sophisticated in health matters, others not. Some may be very self-centered, egocentric, and you want to push them on the delete button so that they don't get too close to you. How do you make a decision that...
Who would be the healthcare representative?
Yeah, because it's really a matter of life or death in a way.
Yeah, I like to ask my clients to consider who is the most calm under stress.
Good point.
Because this is going to be a very, very stressful time. And generally there is one child among the family, if it's not the spouse, right, who is calm under pressure.
Not necessarily the eldest, not necessarily the one
The
who lives closest
closest,
to
that's
you.
right, that's right.
Yeah, we often make that thing. I will share a personal story because I did social work for 30 plus years. There was a case in Rochdale Village, Queens, where I got my first job, and somebody the husband jumped off a balcony, committed suicide for whatever reason. Instantly, like a swarm of hawks, the family came down and thought they were rescuing Mama and take her all the way out of the community to live near them. They did not respect the fact that Mother had her own friends and social support system there. They did not pay attention that maybe she liked the hairdresser, she had built trust with her doctor, maybe she got physical therapy there, maybe she got Meals on Wheels, attended the senior center. Her whole life was invested in that community, and just to uproot her so that they could kind of escape and chase away the memories of that. The father had a psychotic moment and jumped off the balcony. I think it was very unfair and very cruel in not respecting your own opinion. I'd like you to both weigh in on if you had to face that scenario, how you would.
What we try to do is look at those situations before something like that would happen, and actually draft guidelines into the living trust that says if something happens, maybe Mom wants to remain in her home as long as possible.
Right.
She wants to continue going to her place of worship. She wants to be involved in the community. Even if she's incapacitated, that might be what she wants. That goes in.
And needs.
And needs. That goes into the plan itself. So the children can't just run over her with a...
Family coercion, lack of a better term.
Right. So that needs to find, the living trust is a contract.
Yes.
Right? And so the children must follow that contract. So we talk about that with our clients as far as what would you want if you become incapacitated or this situation.
I want to do a follow-up question, incapacity, because this is also a friend of mine. The mother in that particular family developed Alzheimer's, and Alzheimer's are moments of lucidity and moments of losing it. Now, this woman was on, I think, Aricept, one of the Alzheimer's medicines, but she would never reach the point of being legally declared incompetent. If she made some changes in her will or her estate, at what point is she deemed competent or incompetent, and could another relative bamboozle her to change the will in their favor to get a larger chunk of the inheritance while she's still incompetent? That's a
Unfortunately, that's an all too common situation.
Mm-hmm.
And if they use an attorney,
Mm-hmm.
the attorney is responsible for determining whether mom is competent. There's certain ways that we're trained to do that.
Mm-hmm.
We also ask the family member to leave the room, and we just communicate with the client, with mom, right,
Right.
or dad. But sometimes we're not involved in the process,
Mm-hmm.
and the children, maybe through fraud, maybe through some other situation, could be a caregiver, right? And you have the parent all of a sudden changing their plan.
This is what happened. One of the daughters was a caregiver, and she was able to persuade the mother during her Alzheimer's
That's right.
bout, and she was the only witness to the
That's right.
transition. And so one of the big accounts went from what would have been the will to be split between two children to being a joint account
Oof.
to bypass it. You've heard of these
Oh
things
yeah,
before.
it happens. It happens quite a
And,
bit.
and I also suspect that because the doctor involved who gave the medicine all was essentially paid the bill by the daughter, that the doctor was not going to testify or give any kind of medical records that would in any way compromise the integrity of the daughter who.
Yeah.
I would ask how we avoid this.
Yeah, that's one benefit of a living trust. Remember, the living trust is in place while you're alive and during incapacity. So we can the assets are owned by the trust, but the trustee controls the assets.
Got it.
So when somebody becomes incapacitated, a panel, the way we do it, a panel is triggered
Yes.
that determines whether the trust maker is disabled or not. And as we age, many of my clients are starting to put on co-trustees. So it's not just them holding the key to the gate. It is them.
They're actually adding.
They are adding a co-trustee.
Shared responsibility.
Shared response. So there are now two gatekeepers, right? So
Healthier.
if you have this caregiver who's maybe a little shifty, or you have a child who's maybe a little greedy, whatever it might be, right? All these issues, it's going to take two keys to the gate to make the changes. So somebody wouldn't be able to just access that account like they could if it was just a will-based plan. And they got to go through the castle. They got to go through the trustee to get into the castle, right? To get into the account. So it puts up some barriers, some asset protection barriers.
Checks and balances.
Checks and balances that'll make it a lot safer. And certainly as people get older, that's what we discuss with them. And I just wrote one, actually it's going to be signed tomorrow, where the mother just added her son as the co-trustee. So now there's two keys to the castle, right? So it helps protect that.
Have you ever decided to write a book or article about your base of knowledge on estate planning?
I have a book out on philanthropy. It's called Giving. So that's everything you wanted to know about
Really?
philanthropy. I will give you a copy. Okay.
The reason I'm asking is that on this station we also do a show called Our Awesome Authors. Now that I know that you're an author, we can invite you back for a second
Great.
go round.
I try to, I write a monthly column for the medical journal, and I try to write articles for the Statesman and for
Terrific.
again, the more we can educate, because I still feel that people are a little uneducated as far as just needing wills.
My frustration is that we live in a world of instant gratification, and that one of the reflections upon Lee's inviting me here, I don't think we had what's called a credit card debt, and I've had a credit card since I was at least 18, that ever went longer than 2 months. And yet we live, and I'm sure your clients, you visit, they have all of life's good things today. And one of the reasons that why my wife and I could plan is that we didn't run down that wonderful instantaneous gratification of a credit card.
Right. And that's one of the differences that and I call it 21st century estate planning. Differences in culture are so vast compared to the 40s and 50s, right? That personal debt and what we call affluenza, right?
I've heard that word.
Affluenza, right?
It could be toxic.
From the baby boomers below, we have amassed this huge materialistic bent, right? That your generation and my parents' generation didn't have, right?
No. There were folks, there were things that had things, the uncle that had this, or the
Right.
friend, but it wasn't this acquisition.
The materialism and the debt that goes along with it.
Right.
I remember I tell this story during my workshops that when my dad really wanted a 1965 Mustang, right? I mean, that was his dream car. And I remember sitting around the dining table and my parents were saying, gosh, we're $300 short, right? And so what were they doing?
They were saving up the money.
They were going to pay cash for the car. Well, that's unthinkable today, right? But they were going to pay cash for that car. And you know what? Dad didn't get that Mustang until 1967 because they had
Delayed gratification.
They had to save. Absolutely, they had to save for it. And what I'm saying is the baby boomers and below as cultural, we don't have that. Money is too easy.
Yes.
And we're in a very materialistic society. That said, we have to realize and understand that's the culture and plan for it.
Good.
Right? Get that financial advisor, get that estate planner, and start planning ahead of time.
Okay. Before we sign off, and this probably should have been the other front end of the show, I'd like to have each of us say where we grew up or where we came from so that the audience out there has a little bio sketch of who we really are, aside from television non-celebrities, as you can attest to. Let's start with EM. Where did you grow up and what was it like there?
I was raised in southern Idaho, High Plains area, where you have 2 weeks of spring, maybe 4 weeks of fall, 3 months of summer, and a lot of winter.
Wow.
But it was a world of
Rural or urban?
urban.
Urban. Okay.
If you call communities anywhere, because we lived in different communities, anywhere from 5,000 or 6,000 up to 50,000.
Sure.
So that's where I was raised. One of the things that happened, I came to Willamette for my undergraduate work. And I have people here in town that go back to decades ago when I was a Willamette student that are acquaintances that we have maintained. I left the world called Oregon and Idaho and went in the Peace Corps in the Middle East, and then did graduate work in New York City, and that's where my wife and I met, and our oldest daughter
Judy,
was born. And we bugged around a whole lot of places and ended up in the early 80s back here in Salem.
What would you say the imprint of Idaho has been on who you became?
Tough question.
Tough answer.
Very much oriented into the outdoors world. Very
good.
self-confident.
Good.
That
Okay.
I don't care where I go, you'll find me figuring out how to deal with it.
Give me hell, Harry.
Independence.
Very much so.
Yeah.
Okay.
Self-sufficient.
Absolutely.
Eden Rose, once upon a time, you were born where?
I was born here.
Oh.
I'm one of the few native Salemites that are still around.
Well, what was it like in the, not quite horse and buggy days, but
Well, I was just thinking when you asked that question, I remember, so I grew up here, went to South Salem High School and Candelaria Elementary
it's
School.
Saxons, I think.
Go Saxons, right? And my daughter now is the third generation Saxon, so
Wow.
that's kind of exciting. But I remember going out to the Fred Meyer, South Salem Fred Meyer,
Yes, yes.
was like, it was out in the boonies, right? And my mom would say, we're going to go out to Fred Meyer. And it was like an adventure, right? It was so far away. And Lancaster was just a 2-lane a two-lane little road with farms and peach.
It's hard to envision that in
True,
today.
Oh,
true
it's
story.
amazing.
I drove a school bus on two-lane Lancaster Road
Yeah.
as a college student.
Yeah, it was great. So growing up
And
here
you're
was
still spinning your
wonderful.
wheels.
Absolutely.
Yeah. So I went away to college. I joined the Air Force, became an estate planning attorney in the Air Force, and
Where were you stationed?
I was stationed in McCord, McCord Air Force Base, up at where Fort Lewis is in Tacoma. And then I spent time in Ecuador and various other
Habla
places.
español un poquito?
Sí, un poquito.
Okay.
Sí.
That's for our Spanish-speaking audience out there.
Yeah.
Okay. I was born in a obscure place called Brooklyn, New York, in the early 40s, a pre-war baby. My dad was the first father in all of Brooklyn to be drafted into World War II.
Wow.
This is the ploy that failed. He thought by having me, he'd escape the draft. It didn't work. And so I grew up with my grandparents and my mom and my aunt and uncle. And that's probably why I'm close to the elderly today, because they were very positive influences on me back in the early 40s. Used to listen to radio, and there was no television though, but I do something on KMUZ, which is in the radio mode. And I always liked people and inquiring, so that initially I became a journalist in New York in 1963, and I've continued that for 50 years, but I also adopted a second career, which is therapy, social work, medical social work, and that's why some of our discussions deal with medical issues. And I moved from New Mexico, Roswell, where we alienated all those aliens, here to Oregon in the millennium 2000. And I've been here ever since. And I really enjoy Salem. I like the vibrance of the capital and all. I like CCTV and our people over there who are tape recording our show. Let's hear it for CCTV. Yay! Okay. And that's my story. Anybody else want to add anything before we say goodbye? And there'll be another series, usually about every 2 weeks on CCTV. So
I want to thank you for holding these sessions. I think it's critical to, again, from the consumers to educate the way you're doing. So I appreciate you taking the time to pull this all together.
Thank you.
It's for your benefit.
Okay. In the future, we're thinking down the road of having a senior symposium dealing with mental health, possibly with dementia and or depression. And then somebody suggested that we take on the hot topic of human sexuality among the aging. So that should draw in maybe a record audience, who knows. But that's, and nothing will be quite X-rated. Y and Z, but no X's. So enjoy. This is Lee Coyne, your host from Senior Symposium, signing off and wishing you a blessed future. Bye for now.